Okay, let's start now, guys. I told you that we are retracing um, from the back, uh, from the back where we started. We'll be retracing today um, until now. I hope that there was the people who were not aware that we are starting at 8. Now, those people are now aware. Okay, now I have a good network. Everything is sorted. Everything has been sorted. Now we can start. Now, as I've said, that I will be tracing back from where we start, and then we'll be moving on. It's very, very much important that you listen as we move forward, because uh, Monday is a big day. Okay. Because Monday is a big day. All right. Where I hope you can see. Um, you must know that even though we'll have a class, the class of today is like the last class. So you must listen very carefully. Now, we are starting. Uh, let me, I'll be. I hope you can see the screen today. I have the better connection. I want to send you this one when we're done. So I told you, let me see. I told you, and I repeat to you, that property law is about the transfer of a right. That's number one. How the right is being transferred. That is the property. How to transfer? How do you transfer the right? So they try to um, regulate the transfer of a right. Now, I've already told you that when we are doing ILW, we learn about the classes of right. That's when we're doing ILW. We learned that in the classes of a right, we have number one, we have a real right, we have a personality right, we have a personal right, and lastly, we have intellectual right. These are the four classes of a right that a person has in South Africa. The person in South Africa has these four rights. 4 rights. Now, the classes of rights, we have 4. Now, I told you that the personality right is for integrity. We dealt with it in the delict. You dealt with it when you were doing the defamation mostly. So this one, it means that it doesn't apply in the law of property. This one, we have a module called, it's either you deal with it in the media law or principle of electronic about intellectual right. It's about copyright. We don't deal with it here. So it's out. Now we deal with these 2 rights. The real right, which is the right of ownership. Anything that the person owns has a real right. Now I repeat, anything that the person owns has a real right. The personal right is a contract right. They call it a contractual right. Some call it creditor right. By the name, many people prefer creditor. So just because in the examination you have written creditor right, it doesn't mean that you won't get a mark. You are going to get a full mark for writing creditor right. Right? So creditor right, you get a full mark for that in the examination. Now, let's move on. We said that it arises out of a contract, agreement, this one. It creates also, they said that it's a performance. It means that the other party must perform in order to have this kind of a right. Those are the 2 rights that we have in a law of property. Those 2 only. Now, when you have the real right, when you have the real right, you have the right to alienate, which is to sell, which will be dealing with how to sell the property. So what happens when you want to sell the property, the procedure that you must be followed, everything, we will be dealing based on this right. Right to alienate, to sell. Another right that you have is number 2, you have a right to burden the property, right? Burden the property is when you register this right that you have to share with other person, right? Like for example, for mortgage, pledge, those are is to burden. It means that you take this real right that you have, you share with other person. So as a result of that, if you said that maybe we just say Jimmy own the house, right? Jimmy owned the house. Now, when Jimmy owned the house, Jimmy has a real right. Right? Now, you must always mute when you get here.
Oh, please, please, please. Police,
Okay? Let's go forward now. It means that Jimmy, because he owns the house, Jimmy has the real right. Now, if Jimmy grants James right of a way and is registered. When Jimmy registered this right of a way, it means that the real right that Jimmy has is now registered another right in the same title deed. Therefore, Jimmy now will have to share his real right with another person. Now, it means that in this statement, it means that Jimmy has a real right. What about James? Because Jimmy has transferred his real right to another person. The person that Jimmy has transferred, James, will have a real right. It means that James has a real right. Jimmy has a real right. But because Jimmy has transferred it and registered another right on behalf of another person, the person to own what Jimmy has. It means that Jimmy has transferred his real right to another person. Therefore, James has a real right. But in property, we call this real right because it's not the truly right. We call it a limited real right. Because it's not a fully real right. We call it a limited real right. Now, I believe you are understanding when we are coming with this one of a property. Now, we are moving. Now, in the same this one, property law, now when you learn this, in the property law before you learn about the classes of rights, in the property law before you learn, we learn about something that we call the legal subject. Legal subject, legal object. Or they just said object. Now, this we learn from the ILW that we have a legal subject and there's a legal object. In the property law, you will be asked to identify the legal subject and the legal object and whether that legal object is registerable or not. And this question will come with mostly 10 marks. Now, in order for you to answer this question, you must know the legal subject. It's you are legal subject. You are legal subject. Now, legal object, as we know, is anything of economic value. It's anything of economic value. Now, if you can see here, there's a legal subject, there's a legal object. In the property, you will get the question asking. Now, let's apply by looking at this scenario of a Jimmy. We know. What about Jimmy? Jimmy is a legal subject. It means that when you answer, you say Jimmy has a real right. The legal object is a house. Jimmy has a legal, a real right over his house. And what about his house? Is it registerable? Yes, his house is immovable property. So it means that the house should be registered. That's how you write when you answer this question. What about James? James has limited real right. You use against. You don't say against the house. He has a limited real right against Jimmy. And the object is a house, which is registerable according to the law. Okay, now we are moving forward on this one. Anyone who didn't understand about writing legal object and legal subject, this question will be on the examination. So anyone who does not know how to write this one, okay, If you know, now we move forward. Okay, now if you all of you have understood, no problem, we are moving forward, right? Okay, now when we move forward with property, we are moving forward now to another thing. Now, in property, of course, they will say that you must um, describe. This question will be on the examination. Sorry. Describe the nature of right. Describe the nature of servitude. See, describe the nature of right. Describe the nature of servitude. These are two different questions. You must never do mistake in the examination where you have to describe the nature of a right. You tell us about the servitude. I mean, the scenario, the way they put the scenario, you may feel like this one is about the servitude. You must never ever, that where there's a right, you put servitude. Where they say describe the nature of servitude, you put the right. You must never. Now, they can come in the examination and said that, let's just take this scenario of Jimmy, by the way. Now, let's put here. Let's just say that Jimmy grants James right of a way and is registered in favor of him. Right. Now, describe the nature of a right Jimmy has. Jimmy has a limited real right. Right? Describe the nature of a servitude. Jimmy has a personal servitude. Right? You see? Sorry. Okay. Now, if we say that describe the nature of a right, it means that you'll come and say Jimmy has a limited real right. Describe the nature of a servitude. Jimmy has a personal servitude. You see the differences. Many people, when they get carried away in the examination, they will quickly go and write a personal servitude, a land servitude. They just go and write the land servitude. You know why the land servitude? Because there's a right of a way. They don't finish the statement. The statement said the guy has the right of way has been registered in favor of him. So it's benefiting him in his personal capacity. Therefore, it can't be a land servitude, even if it's a right of a way. So you must never get carried by just seeing the right of a way, and then you just assume that it's a land servitude. I repeat, You must not get carried away in the examination because of a right of way, then you just written land servitude. You check we check the registration, whether it's in favor of the person or a farm. If this is in favor of James Farm, this will be a land servitude. But now it's in favor of him. It means that he should change from land servitude to personal servitude. Now, we are moving forward from this one. Okay. Now,
Yeah, before you move forward, just to interject, there is a right. Where is it registered? Is it registered in the deed office or where?
registered means that it has been registered in the title deeds, in the deeds office. Yeah, in the title deeds.
Okay,
Yes.
thank you.
Registration means it has been registered in the title deeds. That is the registration.
Mr. Manya, can I please come in? I'm just trying to make sure that you don't leave me behind in it. So registered in favor of Jimmy, it's a personal servitude. Registered in favor of James is a land servitude.
No. Remember, Jimmy is the one that owned the house. I'm saying that registered in favor of James. If the question that the right of way has been registered in favor of James, it's a personal servitude.
Okay.
If it has been registered in favor of James Farm, then it changes from land personal to land servitude,
Okay.
because it's a Jimmy Farm and James Farm. Two farms make land servitude. But if it's a one farm, which is just given right to another person to use for personal capacity, then it's a personal servitude. You must never forget that.
Thank you.
Yes, it means that it's a Jimmy, it's a James. I mean, okay, let's move forward now. When we go forward, we let me just start with it. We talk about the lease override sale. Now, lease override sale is a common law principle which you must never forget in the examination. When you are reading, please read with understanding so that you understand the scenario. Okay, I said that Jimmy, if he's registering the servitude in favor of James, who is him, then it's a personal servitude. If it is a James farm, it's a land servitude. Now, that's all. Now, in the lease override sale, I'm repeating, leases are made up of two. We have a short term and long term. Lease override sale only applies to a tenant who has a personal right and applies not more than 10 years. This is something you must never forget when you get into examination. The lease override sale principle, which is a common law. This is a common law principle. You must never forget. Applies only to the tenant who has a personal right and applies not more than 10 years. So if the question said that Jimmy has leased a property to Jabu for 15 years. After 5 years of lease, Jimmy sell the farm to a third party. Now, when after 5 years he sell the lease, Jimmy sell to the third party. Therefore, it means that the third party, Jabu, will have what? Limited real rights as a result of the lease override sale. Okay, I hope you are listening very carefully. Now, let's look at this scenario. Let's just say Jimmy has leased the property to Jabu for 15 years. After 11 years of lease, Jimmy sells the farm to a third party. Now, we assume that we are talking about the unregistered, right? Let me make it clear. This is unregistered lease. This is the lease that is not registered. Now, after 11 years, Jimmy sell the house to a third party. Jabu will not have a limited real right because the lease override sale will not be applicable. Therefore, the only applicability will be the formality. You know the Formality Act, right? Formality Act will be the one which will create the doctrine of notice. Therefore, the doctrine of notice will be created by this statute. Okay. Now, let's just assume that the lease now is registered. Let's just assume that the lease has been registered. Now, they have a lease of 15 years. Now, after 5 years of lease, Jimmy sells the farm to a third party. And the question is whether lease override sale is applicable or not. In this situation, the lease override sale is not applicable because the lease has already been registered. Therefore, Jabu automatically will always have a limited real right. It doesn't change anything. I hope now you have understood about this limited real right and this one of a Jabu. Now, let's move forward. Anyone who didn't understand, let me know.
The parts of the doctrine of notice, please can you repeat that section for me?
Okay.
Yes, I missed this.
Well, just open your book quickly. Open your book quickly and go to page 254. Okay, I'm coming when you are opening.
Guys, this question was there in October, November 2023. Question 5. So we need to pay attention to it.
Thank you.
Okay, I'm here. I hope that you have opened your lease override sale. Now, according to the long leases, they have said let's go forward. I read yesterday. They said a long lease is a lease for 10 years or more. In Roman Dutch law, registration was a requirement for the establishment of the lease's real right in this case, which we call limited real right. Now, an unregistered long lease was also valid for the full term against the lease's successors, who had notice of the lease, even if the lessor's successor had no knowledge of the existence of the lease. The lease will still be protected for the first 10 years. This is because of the lease override sale. Now, let's move forward to page 255. 255, if you go there, in South Africa, we have section 1, subsection 2 of the formalities in respect of the leases of the Land Act. Is the one that states that a long-term lease must be registered. So because after 10 years, the lease override sale will no longer be applicable. It means that if you have lived to a place for more than 10 years and the lease is not registered, it means that we will check the formalities in respect of lease of Land Acts. Will create a doctrine of notice, and this doctrine of notice this stipulated that the no long lease shall be valid against creditors or successors under an onerous title of the lessor for a period of longer than 10 years unless it is registered. Now, what if it is not registered or the creditors or successor had knowledge of the lease? Remember, the doctrine of notice has been created here when they said the successor or the creditor must have a knowledge of the lease. So if the lease is not registered, at least the creditor must have a knowledge, which created the doctrine of notice by the legislation. Are you understanding? Okay. I hope.
I think I'm getting there.
Oh, okay. Now you will get there. Okay, that's why I said to you that Jimmy has leased, and then I said unregistered. I'll just assume that it's unregistered. Then I said that the property to Jawu for 50. After 5 years, he sold the property. Of course, if he sells the property, the lease override sale will be applicable because it applies in less than 10 years. Then it will give Jabu a limited real right, right? And I said that what if now he sells the farm after 11 years? It's unregistered. If it is not unregistered, formality of land is the one that will regulate. And it means that the Jabu's future will be regulated by the Formality Act. That one that we're talking about, Formality Act, will be the one to regulate. And it's the one that will regulate whether the third party had knowledge. If the third party has no knowledge, then the lease will expire or terminated automatically. But if the third party has knowledge, it will have to create the doctrine of notice. Then you'll know. Okay, I hope.
I'm sorry to interject.
Yes.
In regard to if the third party has or has no knowledge, right? And what about the case of Grand Disease, Stone Road? Because if I remember well, unless if I'm speaking under correction, it was saying whether the third party is or is not aware, the result is the same.
Which case is that?
Is Grand Disease Stone Road?
You mean on the lease?
Yes. Okay. The very same case that what
Can't see that case here.
okay, I'll check this number, I'll share with
Yeah, because I can't see, or unless if you are dealing with a no, I can't see here. The case of a Corbett. There's no case that you're talking about here. I believe that maybe you are mixing things up. Maybe you are talking
you. Yeah, I
about
mean,
the servitude one. You are not talking about the lease. There's no case of grant here on the lease. On the
okay,
lease.
I'll check it.
Oh,
Maybe
okay.
I'm mixing.
Yeah, I think you're mixing up. There's no such thing as that case you're talking about here. I believe you are mixing up. Or someone can see that particular case. Is there anyone who can see the case?
I'll check it.
In the absence of, can I just ask, so if the third party, I just want to know whether if the third party knew or did not knew of the registration, what happens?
If you have lived in a place for more than 10 years and the lease is unregistered, if the third party has no knowledge, then it's terminated. That's all. If the third party has knowledge, then he will be bound to register. That is the law. Okay?
And then if if the lease was registered, okay, I think I'm answering myself, but I wanted to say if the lease was registered and then the third party does not know about the lease I had with my previous landlord.
If the lease has been registered, doesn't matter whether the person has knowledge or not.
Not, okay.
Remember, the formalities made it clear that unless the lease is registered, I hope you have read out that one. We have read it together. They say that Section 1, subsection 2, made it clear that it won't be valid unless it is registered. Therefore, it doesn't matter whether the person has knowledge about registration or not. And as long as it is registered, the third party will be bound. Right? So, yes, let's move forward. So I think that in that case, you are mixing things up with a servitude maybe and the lease. Lease are leases, servitude are servitude. Now, let's move forward. When we move forward in the property, we said that we have a movable and immovable properties. Now, because we have movable and immovable properties, it means that we have properties that you can acquire the ownership for the first time, and that property belongs to nobody. And we have the properties that belongs to somebody. So it means that in a property, we have a property that belongs to nobody. And then we have a property that belongs to somebody. Now, we also have a property that belongs to somebody, but you find that that property ownership may be terminated because of the rules of the property. Now, we are going to focus on that. Now, we start with original method of acquisition. Original method of acquisition doesn't mean that there is no predecessor. The predecessor might be, but you may find that it's been taken from the predecessor. Now, the thing that I want to talk about, I want to talk about original method of acquisition together with derivative, because they go hand in hand. Derivative method of acquisition. I love to talk those two because they go hand in hand. And firstly, we'll start with immovable. Okay, now let's just create a scenario. And here, if you're following. Now, let's just say James own a flat. He married Jane in community of property. The question is, how will Jane become owner of the flat? Anyone to try?
He will become the owner if he marries Jane in community of property. What are you reading?
Automatically, because there is an underlying contract, which is the marriage in community of property, Jane will become the owner of the flat.
So you are saying that Jane will not register. There will be no registration in the title deeds.
Yes, there won't be some.
Okay, it really shows that you are getting the property now. James,
You said it is automatic.
it's automatic. Jane will become the owner automatically. So when she signed community of property, she's automatically the owner of the flat. There's no need for registration in the title deed. Right? Okay. Now you got it. Now,
Schools with inheritance.
yes. Now, let's just say James own the flat. The state wants to expropriate the flat. How will the state become the owner? That is the question of the property. James owns the flat. Now the state wants to expropriate the flat. How will the state become the owner?
The state will issue a notice to the effect that it will expropriate.
Yes, you are right. The state will become the owner when they issue a notice. And I told you that you must never forget. The day the state will issue the notice, the state is the owner of the flat. Easy as ABC. There is no need for, there is no registration that takes place. Then the state has to issue. The state just issued the notice saying that we are expropriating. Then James will lose immediately, forfeit the ownership. That's all. So how will the state become the owner? By issuing a notice. You must never forget that. So if the state issue a notice, it's not the state only. I told you that even the court order you lose everything. For example, I'll just give by Bushiri. Bushiri, when there was a court order saying that no, they call out his name 3 times. Bushiri, he was not in attendance, and then they said that he has forfeited the property to the state. Once they issue that notice, it's done. The sheriff will attach those properties. They are gone. There's no need to register anything. There's no registration of anything. It's the court order will just say that go and take the property. They will come and take the property. It's done. It's done. So yes, the state cannot come. The state will not become the owner through compensation. Compensation is just a procedure that should be following. The state will become the owner through the issuing of a notice during the expropriation. It's the same as a court order. They issue a notice, then they've expropriated the property. That's all. All right. So it.
Before you move on, so just to interject, in terms of compensation, I'd like to know when does compensation applies? Like, does it apply maybe where maybe they are building a mall where, for instance, James was residing there, or what? I need clarity on that one.
Compensation is a procedure of expropriation. Remember? So if they're expropriating the James flat, because James is the owner, he will be compensated. But it doesn't mean that the expropriation take place when you are compensated. It's just a procedure. So the state can expropriate before you even be compensated. You can be compensated later when the state has already expropriated the flat. So by issuing a notice, your flat has been expropriated. The state has that particular power, right? Yes. Then the issue of a compensation is a procedural one. It has nothing to do with the fact that the ownership of the forfeiting of a property to the state. The state will have already taken the property by them. Now, it means that in the original, the way that I was talking about, in the original method of acquisition, remember, expropriation is a original method of acquisition. Many people, you must never forget this one. It's a method of acquisition. Now, when you get into the examination, don't forget, expropriation is an original method of acquisition. Now, we are.
Before you move on, can I ask a question? Is it possible to rescind the notice of expropriation or the court order?
No, no, those are final. I mean, you cannot say if the court has issued, unless if you're disputing, you can appeal. So they set aside. You have a right of that. But if they issued, they issued. But most of the time, remember, it will be based on, for example, if you are owing mostly, they will use a provincial, they will send you to acknowledge your debt. Then after acknowledging your debt, they will the person you are owing will just use provincial sentence. Provincial sentence made it clear that if you want to bargain, you have to pay. So if you want to dispute, you pay first, then you dispute. If you can't pay first, then they take order against you. Then it means that your property must be on an auction the next day. Okay, so
Okay.
we are moving forward. We are moving forward now. When we move forward, we go to the appropriation. Now, appropriatio is anything that is res nullius. As I have said, res nullius is anything that belongs to nobody, right? James found a jacket that was worn by Mandela when he was in Robben Island. In James Yes, we have a James here who found the jacket that was worn by Mandela when he was in Robben Island. Can James appropriate the jacket? Is the jacket Resnulias?
No.
No.
No, the jacket is not Rasmul because it was by Mandela. So that means that the jacket is Mandela's jacket. It cannot be yes.
No, it means that the jacket is of a historical nature.
I think that's why you mentioned that even if something belongs to a museum, it cannot be
Yes,
Rasmulius.
yes. So for the historical nature, so it belongs to museum. So if you find anything that maybe belongs to Shaka, you cannot appropriate such a thing. Uh, it belongs to museum or to the Zulu royal family. You will never appropriate such a thing. So it doesn't matter whether you are the one who found it, you cannot appropriate. It is about the appropriation. You will never be the owner because of the historical nature of such a thing. Right? So you must never forget anything that belongs to museum or is as a history, you cannot appropriate. The animals that belongs to the zoo or a game farm or wherever that is owner, you cannot appropriate such a thing. But the rest you can appropriate. Now, anything that you have lost, you cannot appropriate. But anything that have been abandoned, you can appropriate. It means that if you abandon something, the other person can appropriate. Right? Okay. Now let's move forward. Mhm. Okay. Now we are still in appropriation. Let's just James has a dog. One night, a dog goes missing. After 7 days, James found the dog with Jabu. Jabu told James that he is the owner of the dog through appropriation. Appropriation. What remedy is available to James. What remedy or which remedy is available to James?
I think it's the dedication to claim the rightful ownership.
Reason being the dog was not abandoned, but was lost. So reunification will take place.
So you think the remedy is a revindication?
Yeah, it is. It is, Mr. Miller. Because the dog was not abandoned, but it was lost. So Mr. James can claim his dog.
Because on the 19th, when we're talking about appropriation, and on the 19th, you are going to write an exam. And we have a James who has a dog. One night, dog goes missing. After 7 days, James found the dog with Jabu. Jabu told James that he's the owner of the dog. Through appropriation, what remedy is available to James? Which remedy? When you have looked, uh, uh, when you have looked into the appropriation, when you have read, do you think a revindication will be applicable?
Yes.
Okay. If you think that way, then let's go to appropriation and see which remedy uh, is the one to choose. Okay, we are. Oh, the spoliation now, right? We have a case of the wreck versus mill. Which remedy was used under appropriation?
Exfoliation.
Yes, the spoliation. I don't know why you guys is because we only focus on the ring to determine whether the person is the owner of the dog or what. We use the spoliation, and it is the case on the 66. You can see.
But you see, when everyone goes for an answer, you tend to doubt yourself.
The reason why I mentioned reunification is the only remedy that we can claim the right of ownership.
Yes, but
So I
remember,
opted for reunification.
remember, um, when we talk about the reivindication, um, when you lost something, you have been deprived such a freedom, such a time, you know, the remedy that mostly is available will be mandament van spolie, you know. So this is a mandament van spolie in this way, or you can choose the interdict. It means that there are two remedies that you can use: the mandament or interdict. Please, when you find this question, don't forget. The question about appropriation, we use mandament or interdict. You must never write a reivindication. You will not get anything. Nobel will be very happy to give you 0. So it's very better you go with mandament or interdict. Choose these two only. Everything will be well. All right? Mandament, van spolie, or interdict. Then you go and give the page number by the case of res versus mill. That's why I come up with that question. And then everything now is well. We are moving forward. You have seen it. And then we are moving forward. Now, when we move forward to assertion. This is good. Now, this is one of your lucky one of a session. Now, let's just say Jimmy owned the house. Jimmy install fiber from Vodacom according to agreement. Jimmy will have to pay for 12 months contract. After 6 months, of payment, Jimmy sell the house to Vusi. Vodacom now wants to install the fiber. Vusi told them that he has become owner through accession. Which case Vodacom can rely on to win the case? That is the question. We have a Jimmy who owns the house. Jimmy installed fiber of Vodacom 1. According to agreement, Jimmy will have to pay for 12 months contract. After 6 months of payment, Jimmy sold the house to Vusi. Vodacom now wants to install the fiber, and then Vusi said, "No, I'm the owner of fiber through accession." Now, which case Vodacom can he rely on to win the case? And then you must also state the page number of the case. Oh, which case law? So that can be good. Yes.
I think we will use the Constance case 76.
Yes, we'll use the constant case. And you are right. On page 76, it means that you are reading and you're understanding, and you have read that case and now you understood. So in the examination, it was gonna be easier for you. It was gonna be a peanut butter. You must never forget this. This was in the assignment of a property. Nobel can bring this one. This is the case, the case of constant properties, right? This is the constant properties. The court applied the 3 requirements set at McDonald. However, in this case of constant properties, there was the irrigation farm. And don't forget about this question was there in the examination, especially 2022, there was this type of a question. So it's very much to understand what has transpired in the case of constant properties, Pty Ltd. In this case, it is the same that we said that let me think. Um, uh, okay, no problem. We'll come back. Now, just go and revisit what happened in this case of constant, so that you know the constant one. They said they held that the the company or the new owner is not the is not the owner through accession, because the contract made it clear that the person has to pay until the last installment. That was the case of the constant properties. So now we know, we move forward, right? It was just me trying to test you about this case. If you know about this case, then everything is good. Okay, now let's move forward. This is the case that we have seen. Okay, now we are coming to the good thing that you love: delivery of a movable. Uh, now this is your food. I know you love it. This is, you understand it very much. You love it. This is the delivery of a movable. Now we are starting. This should be nothing. Jimmy went to his friend Vusi. Jimmy loved Vusi's no, let's not do by the kitchen. Love Vusi's watch. Jimmy asked how much, and Vusi told him that it was 1,000, and Jimmy immediately paid. However, Jimmy, fearing that it's night and he can be hijacked, he left watch in his friend Vusi. What method of delivery is this? We have a Jimmy went to his friend Vusi. Jimmy loved Vusi's watch. Jimmy asked how much, and Vusi told him that it was 1,000, and Jimmy immediately paid. However, Jimmy, fearing that it's night and he can be hijacked, he left watching his friend Vusi. What method, for me, which method of delivery is this? Yes. This is a constitutum. Yes. The method of delivery is constitutum possessoria, because the watch has been left in the owner's possession. So it's constitutum possessoria. You must never forget this when you get into the examination, please. Constitutum possessorium. Constitutum possessorium. So when you get into the examination, just think that if the owner is returning the ownership, constitutum possessorium. Now,
My key words to remember is a lay-by system.
yes, it's a lay-by system. Yes. Now, we said that Vusi wants to go to his friend. His mother decide to give him a watch that Vusi's friend mom bought from Vusi's mother. Vusi delivered the watch. And then which method is this? Vusi wants to go to his friend. His mother decides to give him a watch that Vusi's friend mom bought from Vusi's mother. Vusi delivered the watch.
Atonement.
Yes, this is an atonement. This is simpler. Atonement. We have the other, the one, and the third party. So Vusi was the third party who must deliver the watch to the rightful owner. So this is called atonement. I hope you won't forget about this atonement when you get into the examination. Now, you know about the pointing out, right?
Always remember the advocate goes from them.
Yes. You know the pointing out. You know the pointing out, we've already said that it's a long hand. You pointed out. I'm pointing out that one. I want that one. It's a long hand. Delivering with a long hand is a pointing out. If the holder is in possession, it's a short hand. Now, let's say that James has been leasing the flat from Jimmy. Jimmy decide to sell to James. Which method is suitable? Do you think that there's a method that is suitable? Constitutum possessorium, atonement, shorthand, longhand. Which method is suitable?
I think it's a shorthand.
Shorthand. You think shorthand is suitable?
Yes.
You know
No.
why I asked this question? I wanted to see if you know. There is no method that is suitable because this is immovable. Immovable property must be registered. Must be registered. There is no any movable method that is applicable. This one must be registered,
I think uh,
right? It must be registered. The flat must be registered. There is no shorthand, there's no longhand atonement, there's no constitutional possession. I'm asking this question because many people, they get this type of question, that someone is renting a movable property, and because they've already been in the property, they just say the person has become the owner through the shorthand. No, shorthand is a delivery of a movable, something that can be moved, and a house cannot be moved, or a flat. Therefore, you need to register this one. You must never make mistake in the examination. Um, the house is not a movable thing. It should be registered. It should be registered. Now, symbolic, we know about the handing of a keys. Um, um, it's a symbolic delivery. Okay, we know about that one. Now, I want to test you with this one. Let's just say James own a BMW Beamer. One day, James goes to airport because, let me just say that James wants to go abroad. He called his friend Vusi to come him to airport. James and Vusi drive BMW to airport. James handed the key of BMW to Vusi and said, "This, let me just say that this is your car. I'm giving you." Who is the owner of the car? James or Vusi? Now, here is the scenario. We have a James who owns a BMW. James wants to go abroad. He called his friend Vusi to accompany him to airport. James and Vusi drive BMW to airport. James handed the key of BMW to Vusi and said, "This is your car. I'm giving you." Who's the owner of the car? James or Vusi?
Who's
I think James. It's James.
James remained the owner.
Mm.
There is no written agreement between the two, and James can even come back and claim the car back. Since there's no written agreement, that both can show that James really gave him the car.
Yes, you are right. We look at the abstract, those that we're talking about. then I believe that is coming to examination because um, uh, the Nobel loved those questions. We talk about abstraction; those one of obligation. When we look at this question, this is a movable. Remember, immovable cannot, movable does not need to be registered. Immovable is only that can be registered. The car is not immovable; it's a movable. Therefore, it means that James might have given the Vusi car, but there's no any legal obligation or there's no legal contract that shows that Vusi is the owner. Therefore, James can come back and still claim his car with revendication and still be successfully because there is no legal of underlying philosophy or the contract that shows that there was a transfer of ownership. Another thing is that according to the Traffic Act, you must change the papers of the car. There is no papers that have been changed. So it means that Vusi is not the owner. James remained the owner of the car. Even though he showed the intention, but intention without the legal contract, it's hard to prove. So if he wants to donate the car to Vusi, he will have to issue it with like changing from the papers of the car. Then he changed those papers to prove that Vusi is now the owner, and also to have a contract that shows. But without a contract, physical handing of the key and the intention to donate doesn't mean that the person has lost it, according to the to this kind of equation. So don't forget about it.
Will the circumstances be different if it was not a car that needs change of ownership, maybe a watch?
Well, that one may be different. However, as I've said, that remember, watch are very expensive. Watch are very expensive. So without a contract that shows, it's very hard to prove that there was a there was a changing of ownership. So the contract will always. So it means that they are teaching you that you must never be donated anything verbally. There's nothing that can be donated to you verbally unless if it's something of no legal importance. But if you know, if this thing has been happening. I mean, I remember Zodwa Wabantu was in love with the other guy called Vusi, and now she came to media claiming some of the things that she bought for Vusi when they were in love. Now because they are breaking up, now she wants those things. Now we go to the question whether Zodwa is still the owner of those things that she donated, or Vusi is the owner. You remember that saga of Zodwa Bantu? I think it's 2 years or 3 years back.
Yes.
Yes. So who's the owner? The one who donated during the love, or the one who accepted the donation? Who's still the owner? No. So that's why I'm saying that without a contract, you can vindicate whatever you have donated. Therefore, a contract is the one that can determine. So even if people are in love, to donate through contract is good. So when someone sign a contract that I'm donating these things to this guy, so that when they dump each other, they know that there's a contract that they have signed.
Okay, thank you.
Mr. Vinay,
Yes.
is it possible that we can get the same scenario, but being asked as to how did Vusi become the owner, where we can maybe indicate whether he was the owner through shorthand or longhand delivery?
Yes, he's Vusi. We can say Vusi is the owner through symbolic because he was handed the key. However, when it comes to the legally ownership, it's hard to prove that Vusi is the owner because there was no any a contract or a sale. Remember, there's no sale, there's no contract. It's good if there's a sale. where the Vusi can buy the car. He can claim the ownership via the payment, saying that I've bought this car, I've paid him. But when there's no contract, there's no sale, it's just intention and handing over the key. It's hard to prove. That's why I'm saying that in that situation of Zodwa, Zodwa said that I'm still the owner, but Vusi said I'm the owner. So who is the owner? It's the person who bought, because the one that can prove that I'm the owner, I've bought this, and I just give this person to keep for a short period of time. So Zodwa was still the owner in that one.
But when does becoming symbolic comes into the picture?
If you are handed the key, remember that one, that case of a Lara. Do you remember that
Yes.
case? We have dealt with that case of a Lara in the scenario. Um, in the Lara, they asked the same thing. Remember what they said? They said that a week later, a week after gifting the Mazda to Jerry, Lara realizes that she acted impulsively. She decided to obtain a legal advice to determine whether she's still the owner of the Mazda, or she also required legal advice concerning the possibility that she could claim it back from Jerry. Briefly advised Lara in this regard. So she realized that I've acted impulsively now. I want my car back after donating. But she handed the key. Remember on the scenario, they said Lara handed the key to Jerry and said, "This is your car, I'm gifting you." Right? Now she realized that no man, I've acted impulsively. I should not have given that person that car. I should have not donated. Now, where is the proof that shows that Jerry has been sold the car? There's no proof. Jerry never bought the car, right? There is no any proof that shows. Only the verbally, the words. But the words mean nothing. And the principle of inviolability still applies. You can't lose the ownership without the consent. So without consenting, you don't lose the ownership. So Zodo Abantu was given that guy through the love, but never consented, which can be proved in the court of law. You know, in America, they say this like a mini court that is always on the screen. You know, people in America love to buy things and keep the record. You know, they keep record of things because they know the type of evidence that they will use tomorrow. Unlike us, that we don't wait for any evidence, we throw away, and then we have nothing to prove. So if somebody is giving you something donation, like a car, you must write an affidavit. You go to police station, you sign that the person has gifted me. Then there's a proof. But if you don't sign anything, I can come tomorrow and collect my car back. Because there's no proof. So yes, the person like Jerry, a week later, Lara can go and say that I've acted. There is no, I told you that it's on page, I believe it's around page 96, if I'm not mistaken, right? I believe so, because I showed you. Yes, yes, I told you about this underlying agreement, and I said that it's on page 98. Yes, the legal ground. Where legal system makes the trans. Yeah, well,
Said that the person cannot lose consent. I cannot lose ownership without consent. And here, Lara tells his friend that, hey, I'm gifting you the car. And he is not under influence. Wouldn't that count as consent? Or consent should always be written. Without it being written, it's not consent. It wouldn't be considered as consent.
remember, in court, they use evidence. Then if you consented verbally, you are giving someone a car, consented verbal. Remember, you are donating a house. You consented verbally that, hey, this is your house. There was that question that they say father and the child toast, and the father said, "This is your house, this is your farm." Remember, and we said that the child has never become the owner, not because it's not registering. When we are not talking about the registering only, but the fact that there was no any written agreement that shows. So yes, if you get this question,
Sorry, sir. And this applies to both movable and immovable.
immovable, you must have a written consent. Movable, you might have a contract. Yes, contract is needed, especially on the car. People always go to police station to sign affidavit, even when they are selling each other car. If you have seen, nobody can just pay for the car and then go and get a car and go home. You will need the evidence that shows that you have bought the car. Although you have paid, but you will need something like a contract or affidavit that proves that you have bought the particular thing.
So can I interject?
Yeah, well,
So if I give somebody, say, furniture like couches, right, and then they take them to their house, I'm still the owner even though I've given those away. Obviously, there's no written contract, but then I said you can have them. Am I still the owner still, even though they've taken them to their own house?
well, remember, the movable things depends on which one is the movable. Uh, Remember, according to the car, you must change the papers of the car. I mean, the car is the papers when you buy, right? It's not like a fridge that has nothing. You understand? So the fridge, of course, if you give someone, you hand to someone with the intention you have delivered, because there's no transfer, like there's no act for this. Unlike the car, you must register it, right?
Remember the example of the red couch and the blue couch?
Yes, but
Sorry,
that is a car. That is not um that is a chair. But we must look onto the page 198 for examination purposes. But remember that other one. I said that Sarah, the red chair. I said that Sarah is the owner because there was a physical handing and delivery. So that object doesn't need a contract. Maybe it's not like a car. It's different from a car.
okay, thank you, sir.
Mr.
Yes.
Mune, are you saying in movable properties there are properties that should be registered and that cannot be registered for one to become the owner?
A car must be registered. You must change the papers. If you have a car, you have a paper that proves that you own the car. And if you are selling to somebody, you'll change those papers. Right?
Can we go back to
And obviously, the chairs don't need registration. So meaning the delivery and the consent are sufficient for the couch, for the acquisition of ownership.
Yes, but it's not the car. The car is the papers that prove
so
that you need to change.
sorry,
I'm saying that those that. Hmm?
sorry, sir, can I put in? Yes, there is a difference, Kalifas. When you are buying the car, it's not like you're buying a couch. There's a difference when you are buying a car. You have to register the car from the traffic department.
Yes.
And then you get the papers of ownership. That car is registered on your name. Everything is registered on your name, and then you've got the license, you've got the disc there that is registered on under your name. Unlike the couch, even if you can sell the car, you're not going to sell the same as you are selling the car. It's different.
Yes, that's what I'm saying. That the movable like a chair is different because only the physical handing and intention is enough for those delivered. Unlike the car that we can check the papers and we say that you never change those papers. So now you have make me to come to this one. Let's the last question. James and Vusi. James is renting a Vusi house, right? And then James' friend Peter decided to borrow James a fridge. James fails to pay a rent. Now, Vusi, as an owner, decided to enforce a tacit hypothec over the fridge. Will Vusi succeed? It's been long without asking this question. I even forgotten about this question. Now, because it came to examination, I'm back now. It's the last question, guys, for today. We have a James. James is renting a Vusi's house. James' friend Peter decided to borrow James a fridge. James fails to pay rent. And Vusi, as an owner, decides to enforce a tacit hypothec over the fridge. Will Vusi succeed? You think that Vusi can sell the fridge? Vusi said, no, I want this fridge to be sold so that I can reimburse my money, my rent money. I want it to be sold. Will Vusi succeed?
Can I try?
Yes.
Okay, you can go.
I think Wusi can succeed. The reason I'm saying that is because it's not stipulated if James had informed James that he is the owner of the fridge.
Okay.
So the reason is that because the fridge is in the premises of Wusi, it belongs to Wusi.
Yes.
I think that Lucy, as the owner, can succeed on enforcing a tacit hypothec over the fridge, since James does not even know that the fridge belongs to Peter. To who? To James, to Peter or James. So, and it's there for enjoyment and use indefinitely. We don't know how long the fridge is borrowed there. So basically, the Peter is using the fridge like indefinitely. I don't know how to explain that, but yeah, that's why James, as the landlord, then can enforce the tacit hypothec.
Yes. even if VUSI has been informed, VUSI can enforce the TASIC hypothec. It's in the VUSI discretion, by the way. So any goods that is in the hands of the tenant, the landlord can enforce the tenant, the TASIC hypothec.
Please mute.
Okay, guys, I hope that most of the things we have done, we have covered. I was just covering for those that tomorrow I know that they won't be with us because they will be going to write, and then there will be others that they won't be with us. They will be writing labor law. There will be others who won't be with us. They will be writing uh, what is that? The company law. So yeah, they won't be with much. People are going to be preparing. So it's gonna be a hectic week for others, especially this week and next week. Most of the modules have been written in this end of when we go to end of May. Now, no problem, guys. We have done much today. I hope I have opened the eyes of many. At least now you can get 50. Yes.
Anyone please explain to me a little bit about this text hypothec.
TASIC hypothec is being enforced by the owner. We call it a rent interdict, but here in property we call it a TASIC hypothec. If you are owing, they enforce so that they can sell the goods and reimburse the money that you are owing. That's all. You are owing, they sell whatever, they can get their money back, and then they get their money back. But if you remove the goods before they attach the TASIC, before they enforce the TASIC, then those goods are no longer part of the TASIC. So the only way to run away is to owe the landlord and run away with the properties. That's the only way. Okay. Now, no problem. Let's go to sleep, guys. We'll see tomorrow.
Are we meeting at 8?
No, at 8. Tomorrow. Yeah, but many people are writing. Let's just 8. But if they were not people, I was just suggesting that we go a little better than like a 7. What do you think? You think 7?
I'm fine with 7.
We are being busy.
Yeah, you know, 7 is fine.
I'm also fine with 7.
Yeah, 7 is fine.
7
Yeah, let's go 7 tomorrow so that we give chance those who are going to write. No problem, sharp.
Thank you very much.
Thank you, sir.
Okay.
Thank you, colleagues, all the best for the coming exams.
Okay, guys, from the TikTok, we have pushed today. I think from 8 now past 10. I've pushed today because I was not having any modules. I've done with the international law, I've done with company law. So yeah, that's why I've pushed so much. So all the people that are taught company law are done now. just finishing this property law, then everything is set. Okay, sharp, let me go sleep.